Professor Lau, can you talk a little bit about some of the precedent regarding the advancement for civil rights for the LGBT community, the evolution of this precedent?
Let me talk a little bit about the huge advancements that have been made in terms of doctrine regarding sexual orientation law, especially doctrine that has developed in the area of same-sex marriage, right? Until fairly recently, there was virtually no precedent to be cited for the proposition that sexual orientation discrimination should be subject to heightened scrutiny, this idea that sexual orientation is a suspect or quasi-suspect status. But over the past few years, we've seen a crystallization of jurisprudence to support that point. The high courts of California, Iowa, Connecticut have all issued opinions saying that sexual orientation is either a quasi-suspect or suspect status. We saw the same conclusion reached in Perry versus Schwarzenegger, in Eric Holder's memo on DOMA, as well as the recent tax court opinion from California. And that's been huge because prior to this burgeoning of jurisprudence on this point, a lot of courts concluded in the opposite direction. We could, as a contrasting case, look at Anderson versus King County from the Washington Supreme Court. I think that case is from about 2008, in which they said no, sexual orientation is not a quasi-suspect or suspect status, and they cited in a string cite a lot of old cases that came to that conclusion. Now, a lot of those cases were problematic to cite because they relied on Bowers versus Hardwick, but now we've seen the jurisprudence really reach a new point, and there is good case law, persuasive case law in many instances, but case law nonetheless that courts can make use of to support the idea that sexual orientation discrimination should be subject to heightened scrutiny. And I think as a matter of legal doctrine and principle, these courts are getting it right in applying the legal test for suspect status or quasi-suspect status. In particular, I think these courts are getting right the question of whether or not a group needs to be politically powerless and whether the trait involved needs to be immutable for the status to be considered one that triggers heightened scrutiny. Right? I think these courts are getting it right by defining immutability broadly, and not just to look for traits that are biological, but traits that are so significant to an individual's sense of self that it would just be wrong and unconscionable to ask someone to change that trait, such as sexual orientation. As for how to measure whether or not a particular group of people or a status is related to political powerlessness, I think these courts are right in saying that we have to take a broad understanding of what it means to be politically burdened, right? Because groups defined by sex as well as racial minority groups have seen a lot of progress in terms of political power, yet they're still burdened in the political domain, and courts continue to treat race and sex as suspect or quasi-suspect statuses. And so for these courts grappling with sexual orientation now, to maintain fidelity to that existing jurisprudence and the way courts are treating race and sex, it is consistent to say that political powerlessness has to be viewed in these broader terms. Another area of jurisprudence that I'd like to highlight that I think is worth celebrating is this rebirth of the sex discrimination argument in same-sex marriage litigation, right? Both the court in Perry versus Schwarzenegger as well as the recent tax court opinion from California recognize that sexual orientation discrimination is a type of sex discrimination. And I think that is a point that's really important to drive home. As a formal matter, right, whether or not a man can marry another man depends on his sex, right? Because if he was a woman, he could marry that man. But as a more substantive matter, it's a helpful lens to view marriage, because marriage historically has been a sexist institution, right? There used to be very rigid roles for the husband and the wife in the institution of marriage. And in many regards, this threshold question of whether or not the sex of the couple, the fact that we still look at sex as a threshold matter is really a relic from the past that was tied to marriage's sexist past. And I think it's right that these courts are making that connection between sexual orientation discrimination and sex discrimination. It also helps us look at the marriage equality debate in the broader context of public culture, we see that a lot of opponents who oppose same-sex marriage make arguments that are based on gender stereotyping, this idea that men and women need to complement each other, the idea that children need to be raised in an environment with a man who could be a male role model and a woman who could be a female role model, right? Those sorts of arguments presuppose that there's a particular way to be a man and a particular way to be a woman. These arguments rest on gender stereotyping, stereotypes that are really in contradiction to the anti-stereotyping principles that have been established in our sex equality jurisprudence. So I commend those courts for connecting the dots between sexual orientation discrimination and sex discrimination.
The Obama administration's decision not to defend a portion of the Defense of Marriage Act in court as constitutional. Can you address that a little bit in terms of, I know it's not creating precedent, but how is this helpful for other courts considering the Defense of Marriage Act?
Well, right. Even though it's not necessarily binding, right, Eric Holder's memo, we see that it is already making waves in legal decisions. The tax court opinion that was discussed on the panel cited Eric Holder's memo, right? In part because I think the reasoning in that memo is very strong and sound, right? And in terms of the broader court of public opinion, I think the Obama administration's take on DOMA and the fact that sexual orientation is a status that triggers heightened scrutiny, that generates a lot of conversation that is helpful to those of us who are interested in advancing LGBT rights.
Okay.